Hi folks, my name is Kathy Yudis, coming to you live from St. Louis. This is my third attempt at making a video to try to help the American people understand exactly what we're up against with the mortgage foreclosure crisis that some people just may not understand. So I'm going to go into a little bit of depth. Basically, I took a job as a mortgage collector in 2001. I worked for a large collection agency by the name of National Asset Recovery Services. And when I accepted my position in 2001, I asked them if they had the right to sell mortgage notes for the bank I was collecting for, and that was for Chase and for Citi. And I was told for Chase they had the right to sell mortgage notes, but for Citi that they did not. So I did not sell mortgage notes for Citi, but I did for Chase until come to find out that they lied about having the right to sell mortgage notes in their contract. This was found out after I took money from an investor to the tune of $80,000, and the only way I found out that they lied about the right to sell mortgage notes was when they took this money from this investor. They decided they weren't going to try to sell her the mortgage notes now. Come to find out, she's a very rogue debt investor, but what she does is she buys notes before they go into foreclosure to try to make as much money as she can. So, at any rate, I lost my job because I did not hang up the phone on her, because I didn't know how bad of a rogue debt investor she was or anything like that, because there was no type of due diligence that we did on investors who bought mortgage notes from us, Basically, the lady contacted me and told me Chase told her to contact me, and so I did what I was asked. Well, even though I did what I was asked and I did what I was supposed to do, which is speak out and continue to speak out and tell the truth, I have faced nothing but corruption in doing so. After they lied about the right to sell mortgage notes, I went on and tried to, be in business for myself, because I had bankers that wanted to make sure that if I didn't end up a hard luck story, that I didn't. So I took, an associate of mine actually came to me and said, "Hey, you know what, I do know that Citi sells their mortgage notes, and if you have the buyer, we can try to take them there." And I said, okay. So I took Citi one client that had $150,000 a month and got told that they weren't spending enough because they weren't spending $3 to $4 million a month on mortgage notes. And I said, okay. And I took them another client that had $10 to $50 million a month to spend on deficiency balance notes. And come to find out, that deal didn't happen either, because once Citi sold the mortgage notes, the deficiency balance notes, to my client, they still wanted to make money on them. Well, how do you make money on something if you just sold it? That's like me selling you a car for $5,000 and say, "Hey, give me $100 a month extra," for whatever reason, even though you just paid for it. So, long story short, I've been fighting the banks since this has all happened, and I ended up having to file my own Chapter 13 because my own attorney didn't believe nothing I tried to tell him about the impending foreclosure crisis with the fraud being put into the court, even though we proved that Wells Fargo came to court knowing they did not know who owned my debt when they put the proof of claim in the bankruptcy court to be paid. So that's filing a false proof of claim, which is supposed to be a $500,000 fine. They were only dismissed without prejudice. My first mortgage wasn't endorsed properly, and the person who put in the initial foreclosure work with Home Ec, his name is John Dennery, and he was with Wells Fargo, and now he's the national director at Fannie Mae. So, you kind of have to go back and check on things and figure things out. But, I have a very detailed list of information regarding the foreclosure crisis that most don't have and won't have unless I try to make sure that I express who I am and the fact that I've tried to do right all along to make sure that if I could stop the foreclosure crisis that I do, because so many people would be affected by the foreclosure crisis. So when my own attorney refused to represent me adequately, I let my first Chapter 13 get dismissed. I filed another, and when I put it in, I didn't put in a plan, because I had hoped that, if I have a valid way to pay my bills and have every one of my bills paid for in 5 days or less, that I'd be given the opportunity to do such, which is the use of having people to help you make sure you don't end up as a hard luck story. If nobody else has to do a fair job or do proper business, and nobody can give you what the real business law is on this. So, when I filed my attorney's adversary along with my own, they decided to remove it for the court record, and the judge dismissed it because I didn't file a plan. And going along with this story, after using the court process, come to find out they lied to me about the right to sell mortgage notes from the very beginning, and they've lied to me about my true identity my whole life, that I should be worth millions, but instead I'm being told that I am broke because I tried to stop the crisis, all because of who I am, and I understand more than most. Well, what I'm going to do is I'm going to read over the motion to vacate that I put into the court, so homeowners will understand that I pleaded, and I'm still pleading, to try to do the right thing in our country, to make sure that if somebody doesn't lose a home, that they don't have to, that people are jailed that need to be jailed because of the fraud that they're perpetrating on every American every day with false stories, because they've had an opportunity to resolve this whole crisis since 2008, and yet they still refuse to do anything that would actually benefit the bankers, benefit the homeowners, benefit the investors, and restore some common sense of morality to people that work every day to make a change in making our world a better place to live. So I hope you enjoy my motion to vacate and the information that I have afterwards. Dear Sir or Madam, I write this as a final attempt to draw the attention to what I find a very un-American way of practicing law. We have asked the court to review our case just to find that the court has refused to consider submitted evidence by us and instead relied on hearsay and verbal communication with the other party. We are American citizens, granted protection by the Constitution, where everyone is granted the right to a fair judgment and where no preference is to be given to sex, creed, or color. Now we face foreclosure on our house, where the court has denied us fair representation and ask for a motion to vacate until the courts have considered the case properly. We realize this in attempt number 3 to receive a foreclosure restraining order. The civil case was filed as a counterclaim, meaning judicial review, Article 3, common law rights, for the decision of Senior Bankruptcy Judge Barry Shermer here in St. Louis. You just request these courts to clarify in full the reason behind denial of property ownership laws, as well as laws and regulations related to the transfer of ownership of notes pertaining to identifying the rightful beneficiary to any payment obtained from the foreclosure. There is a will and intent to meet and negotiate terms and conditions with such a holder of notes that this may find gives a better payment on default than on foreclosure. The ruling of the court is thus damaging to both parties, us that owe the monies the bond represents, and the owner of the note that face a minimum dividend on a settlement. The only institution to benefit from the ruling is the bank as the lending institution. We do not find this as fair and ask for it to be considered improper protection of the lending institution. The court acknowledges that I used to be a mortgage bill collector for a living. I would here like to present some of the background that may have contributed to the court refusing to review my case properly. This is not to be construed as an alleged motion to vacate, but one based on the truth and this only. I've always been told that judges in our country are elected by the people to not be biased to anyone. I have always taken it for granted that the elected officer was to uphold the U.S. Constitution, state and national laws and regulations, and in particular also property ownership laws. I will try to show that for the third time I find the judges have not served the law and sought justice, but by clever procedure avoided justice to be served. I admit I do not have access to or knowledge of all the statutes, codes, and rulings that form precedents and background. Unfortunately, I've been able to find an attorney to represent us adequately. I have asked the court for one to be appointed and been denied help. Therefore, I'm not totally aware of how I could help us more in showing cause. We have been told by City Financial of Robert Hayes in the Arizona Loss Mitigation Department that City Financial considers this case a nuisance. There was a summons, a subpoena dosis ticum, issued in the filing of this counterclaim. No one but us has requested City Financial, or possibly now City Mortgage SPM, to show official ownership title of our promissory notes or security instruments. In my years of employment and now these complaints, I've learned about the banking business and the law. Regardless of what case I could put here for Missouri or around our great country, it seems to us the federal courts in St. Louis are not serving justice since they ignore my simple motion. We feel this court has tried to make us responsible for things beyond our control. We've never denied that we owe someone for our debts. Every law we've read dictates ownership is proven by having it in hand if requested. None of the memorandums or orders have been clear, and the courts continuing to deny our claims of property ownership rights. Neither Judge Shermer nor Jackson has any indication of what we have attempted to do right by everyone involved. We're just made to look like deadbeat debtors for requesting what we've always been told the laws are. So they do not defend property rights, which would not be to defend the rights of those that own the notes, nor do they protect or shelter those that are delinquent, but shelter and protect acts contradictory to U.S. and state laws. The court says our motion for injunctive relief doesn't show irreparable injury or damages. The home for our 4 children has now been foreclosed. We've tried everything to prevent it. We paid for a home until it was obvious we couldn't no longer at that time. Background. This information below is mainly about Catherine Udis. This is information to show, regardless of adverse conditions, we or I've always attempted to do what the law requires. I was born in the state of Missouri in September of 1968. I grew up the oldest of 6 children. I ended up living between Missouri and Texas in my childhood. I've resided in Missouri for most of my adult life. In my life of 40 years, I've attempted to overcome adversity at all costs. Below are some of the things I've attempted to overcome. No known father. 2 kidney stone operations between the ages of 5 and 7. The day before my 3rd operation for the removal, miraculously, my kidney started functioning and I didn't have to have it removed. Epilepsy. After I fell on a horse as a child, I started having the worst seizures possible. Grand mal seizures. 11 years ago, it was made known to me I had a ruptured disc in my lower lumbar, along with degenerative arthritis. These horrible conditions affect all of my limbs. I did have it fixed in December of 1996 by Dr. Daniel Scuderi prior to marriage in June of 97. 2 days after Thanksgiving, 1997, my husband's grandmother in Pittsburgh died. I left work that Saturday morning to pick up my husband from work so he could go to the airport for her funeral. Unfortunately, my back was re-injured in an auto accident instead, by a motorist who lost control of their van and ended up coming at me across 4 lanes of traffic coming westbound and eastbound Highway 70. The attorneys decided because I previously had an operation on my back, the most they would compensate me was $10,000, not enough to substantiate the damage done to me. I've been living as a re-injured status since this time, out of fear that if I have another back operation that I may not even be able to do the things I'm able to do now, like barely walk or maintain a home for my children. Every time I have a back operation, my chances for recovery lessen each time. However, whatever happened in the automobile accident left me seizure and medication free. While unfortunate, I quit high school and got a GED. I then went to Secretarial Business College. The business college made me go by my mother's income for student loans, even though I lived with my grandmother. To me, there's no way I should have been forced into student loans instead of Pell Grants. My grandmother didn't make enough income by any means that I should have been required to take out student loans. Obviously, though, knowing I needed more of an education, I couldn't refuse trying to better myself. After going to business college for secretarial work, I had a hard time finding employment that would give me an opportunity to use my skills, much less support myself or a family adequately. This therefore led me to default on my student loans. That's when I learned of the collection industry. Not too long after this, I attempted to get a job doing collections. The first employer I worked for was Client Services. After 3 years and no real opportunity for advancement, I took employment with someone I thought was a friend. Unfortunately, it was short-term employment. This led me to Outsourcing Solutions Incorporated. I worked there twice. The first time it was found the file lacked capability to be collected on. The second time, under the direction of a different manager, I proved to be an asset to the company. In late 2001, I accepted employment with National Asset Recovery Services as a mortgage collector. While there may be a lot of collectors in our great country, once City Financial or Chase charge off mortgage notes, there's only a few third-party agencies that get these to collect on. The position initially went well. I worked the charged off Chase mortgages. Then at the discretion of another manager at NARS, Dean Christensen, I was made to move by 2 other mortgage collectors, Dennis and Jeanette. They collected on City Financial Associate files. Then they merged all of our files to collect on. This was done as the placements coming into the office were not what they once were. This was done in an attempt to give us all more files to work since the placements were down. Plus, I had proven I had the capability to collect on mortgages for Chase in previous months. Then they removed us to another building as they had offices across the street. Apparently, they didn't want other collectors to hear us talking to the debtors. However, they also wanted us to be under the control of a different manager, Steve Patterson, with Dean Christensen overseeing him. In this position, monthly on a regular basis, either Mr. Smith or I collected the most money for NARS. However, I learned that there are legal methods to collect a debt and illegal methods to collect, so I exercised due diligence to uphold the laws and regulations pertaining to this work. Upon encouragement by Mr. Christensen, we were called into his office to be told how we weren't collecting enough money to be in competition with other agencies for them to keep Chaser City Financial as a client. There were times we were told to act on his instructions and ignore legal issues. In these positions, we collected on defaulted mortgages that for whatever reason Chaser City decided not to foreclose. They were written off as charged off. Mr. Christensen on a regular basis was very demeaning to us. These actions of Mr. Christensen made me inquire with a former employer that I knew about his methods. What I was told was repeated once. I was told that he was instigating similar circumstances that he had been terminated for in his prior position. I was then led to believe that he would tell me more given a more casual opportunity concerning the unwanted advances towards other employees and such. This person then went to Mr. Christensen to inform him of what I said, and Mr. Christensen then approached me. At this time, he threatened me with suit. This wasn't the only issue I had with Mr. Christensen, as we seemed to continually butt heads. He knew I knew my job. So did Mr. Patterson, so much so that when City Financial brought auditors into the office, I was the main one, besides Mr. Christensen and Mr. Patterson of management, who spoke with them. Besides Mr. Patterson, I was the main one to do reviews on our files to make sure they met adequate working compliance for best worked efforts by both clients, City Financial and Chase. Mr. Christensen on a regular basis acted like a tyrant. Anyone besides me can even attest to this. In my employment with NARS, I birthed 2 children. After my 4th child in December of 2003, I went back to work, and shortly thereafter I received a telephone call from a woman named Nancy Tedeschi. She informed me that Chase had given her our number to contact us about purchasing defaulted mortgage notes. We were always informed that we had the capability to sell mortgage notes for Chase. We ended up selling her some of the notes we knew were available for sale. The selling of these notes this time, something different happened. Besides a delay in the usual assignment of mortgage from Chase or a phone call from an angry investor, still waiting after a couple of months for this information, apparently after Ms. Tedeschi paid the $80,000 for the non-performing mortgages, she immediately sent a foreclosure letter to a defaulting debtor, Mr. Pandolfi. She did this without waiting for an assignment letter or the by law required hello goodbye letters to be sent. This immediately made Mr. Pandolfi file suit in Pennsylvania. This is when it came out that NARS never had it in their contract to sell mortgage notes for Chase. In employment with NARS, we were told the minimum requirement we could accept on any mortgage note was $5,000. We were told to get more if we could, but if the file that capability to do the best effort, then if necessary, sell the notes to investors who inquired about purchasing such notes. However, we had no way to verify if the investor was legitimate or not. It's not like there were several investors we worked with. The Pandolfi note was placed in our office prior to the sale to Ms. Tedeschi. He was in default upon placement in our office. He didn't seem to want to make amends for his defaulted debt. Unlike other people, he probably had the capability to do such. He chose to fight his case legally through the court process. This, of course, was after what Ms. Tedeschi did to Mr. Pandolfi. Excuse me. For whatever reason, I determined it would be nothing but a battle with him to get him to negotiate with us, so I requested his file to be removed from my queue, and they gave it to Mr. Smith. Being a mother of 4, my income is important to my family. My job was everything to us until I was initially contacted by Ms. Tedeschi. I came to NARS with collection experience in credit cards and mortgages, and I knew a lot of collection laws. I'm not an attorney. These court experiences are new to me and my husband, David. See, we've never attempted to come to such a situation in our life like the majority of people. However, Ms. Tedeschi introduced me to her way of business practices. She offered a part-time job. I thought I could possibly make extra money to support my family. I never not once worked as long in my adult life. I haven't tried to get Social Security income or anything with the injury I've suffered. In our difficulties, we've only received food stamps once for our children. I obviously have lacked good judgment in believing anything read or anyone has told me in my lifetime. I didn't know the harm that could be put upon me with the type of business practices she introduced me to. I didn't per se have a contractual management position with NARS, but I did have one of the better positions within their firm. NARS management on a regular basis made me question their business practices. While Mr. Patterson sometimes did attempt to give advice in difficult files, most times I'd be told, collect the money. The client knows they placed it here, now collect it. He did not want me to uphold FDCPA laws or other laws and regulations. This caused me concern and raised questions about the ongoing business practices, so much so that it got to a point that I'd have to call the client Chase or City Financial. Most often, it was the Chase files. I'd have to literally call Chase to request if the file was supposed to be in my case or in my queue or not. If I did not do this, I would have been forced to break the FDCPA and other regulations. Therefore, after I'd call, and after my questioning, Chase would call and pull the file. Ms. Tedeschi operates a title company in New York. She on a regular basis does her best to get over on anyone she can. Besides having a title company, she acts as a private investor judgment creditor. While this isn't against the law, the business methods she introduced me to have caused me harm. I've always attempted to follow the law in doing any business practices until this happened. I've never had this type of conflict of interest happen in my lifetime, in or out of employment. I, being naive about the total process of buying foreclosures, didn't know as much as I should about the proposition to me. You can try to speculate my judgment on this. To me, if I am wrong, she wouldn't have already tried to sue Chase again. She agreed to hold them harmless after the settlement that was obtained for NARS never having it in their contract in the first place to sell mortgage notes for Chase. However, most of this information has been learned since the circumstances her job offer caused. There has been a state of confusion caused by all sides. See, there was this voice in my head saying, oh my God, now they're going to steal money from an investor. For 2.5 years, I was told they had it within their contract to sell mortgage notes. For 2.5 years, I probably had one of the best jobs of my life, regardless of some of the circumstances surrounding me and my environment. In speaking with Miss Tedeschi, I wasn't the only one she apparently taught her legal practices to. She likes taking the judgment creditor position and not let people know she's bought their mortgage note prior to a foreclosure. Especially since she targets foreclosure, she knows the bank will take less, which gives her the opportunity to make more. Most don't know she's even done it. Her so-called offer of employment caused a conflict of interest in my relationship with NARS. I found out the hard way her business practices are lethal and illegal to get what she wants, money. While the law dictates in Missouri a right-to-work state, you can be terminated at any time with nothing. The business practices of these corporations have harmed me. See, I asked if they had the right to sell mortgage notes in the very beginning of the acceptance of my employment. They intentionally deceived me by telling me they had the right to sell notes for Chase. It was found out in the case that it was an assumed practice from when Chase bought out Advanta. The City Financial and NARS were no assistance when it came time to explain their business practices to me. I know of at least 2 cases within my time of employment they placed accounts for collections knowing they never should have been placed. See, the people filed Chapter 7 bankruptcy. Upon arrival of accounts at NARS, they demanded we call people blindly without knowing anything about the account place. NARS immediately wanted us to be collecting as much as we could on accounts. Calling blindly encourages error when one has filed bankruptcy or having no knowledge of one's capability to repay their debts. In my professional history, I've found most agencies want no one to do due diligence about clients' debtors in an attempt to do an honest job of collections. No one should be ridiculed for wanting to know information about the job they're supposed to be performing. Going forward, these 2 accounts should have never been placed for collections, not just because of bankruptcy. City Financial has the capability to have hired adequate representation, but for whatever reason, they were negligent in collecting their money on a home after a tax sale, even though the debtor had walked away and abandoned the home. When this happened, they had me contact him as there was a form needed to get the money back from Cuyahoga County, Ohio. The debtor in question was willing to sign whatever they wanted him to sign to obtain this. Then, they never come up with the proper documentation to do such. He should have been done never to be contacted again. But, excuse me again. But just like now, City Financial or these banks have no concern about how they collect or ask other people to put their lives on the line. I had debtors that I requested title reports on. They were mainly for City Financial accounts placed with us. They always talked about getting us a machine to do such, but never did. There was a lady that had a fire in her home. She believed her mortgage was paid from the insurance paid off. Well, I don't remember her name. They never would give me supporting evidence of the debt being paid or not paid. They just wanted me to collect the money. Any of these transactions can be verified by checking the files. I worked at NARS. Of the two clients, City Financial was the most notorious for not only giving accounts with no capability to be collected, but had the most legal issues. Chase gave accounts that had capability to be collected, although at times I feel they placed accounts that shouldn't have been placed. One such account is of a homeowner who had perfect credit besides the second mortgage he had with Chase. He claimed he never knew he had the mortgage. I would agree with him, as he paid within a couple of months of being placed with us. There was a debtor in question that was hard to locate. I got in trouble for calling Chase to have them complete the transaction, as there was no Spanish speaker available to assist them. So I called Chase, and they were more than willing to assist. This was done as the debtor was a hard-to-locate person, and I was able to track down the debtor successfully for Chase. Rumor is the accounts Chase placed with us had not been worked on, were sitting on a shelf somewhere. While Mr. Patterson claimed Chase worked them prior to placing with us, there was indication this wasn't entirely the case. It appears to us the court just thinks we should be left destitute. The circumstances I've endured throughout my life I can't change. Neither can the corporations mentioned within. I've done my best to not beg, borrow, lie, or steal from anyone throughout my life. I've always been taught to respect what I have. I've attempted to do this with physical possessions and other people I encounter as well. After the conflict of interest that I lost my job over, I attempted to go forward in doing business. I attempted but failed in a business investment due to an associate disassembling the business out from under us. I had hoped to get some help in determining who really owns my mortgage note when all this started, as I know of no one who would ever want to pay twice for a mortgage. My bankruptcy attorney knew this. There are probably things that shouldn't have happened. It would be different if we haven't repeatedly asked for help in understanding how to handle such circumstances. While I know about bankruptcy laws, as my understanding, judges are supposed to judge on the facts. The facts in this motion to vacate have intentionally been left out of any of our complaints, since we have a right to a private life, to be left without intrusion, to not live in fear for our lives. It also gives anyone knowledge about me, since this motion to vacate is filed here, to be open for review by anyone who wishes to investigate, may use it against me. This information is my own for the most part. I've been requested to leave these pertinent details out of our complaints, not by the corporations mentioned within. However, circumstances are such that we do not want to go through this set of horrible circumstances, whereas the behavior of the courts apparently requires it. To me, they are important facts that have led up to these attempts to rectify our financial, now personal, business matters. I've tried, just like always, to accept what has happened and go forward. I'll admit, it may seem I'm hostile. I've done everything to not do harm unto others, even though harm has been done to me. Until we've been pushing these complaints, the court has denied us access to attorneys after we informed them that no local attorney would take our case. We did pay for representation and the court's protection with payments when we could. We've always done our best to make amends to the best of our capability. I felt my initial adversary would get Judge Shermer to see the violations in my case, as I've been forced to learn about the law in order to protect my home, family, and now rights to even an income. As being in the banking business, or employers in general, require impeccable credit. In my wildest dreams, this is not a situation I could have ever dreamed up. I've always tried to be honest in doing the sacred job of protecting one's interest, whether it's a homeowner or one of the clients I may represent. I started in collections in 1994. I've tried getting knowledge to educate myself more adequately to change professions out of collections. No one is interested in attempting to assist me. Or else, maybe I could have been able to become a mortgage underwriter some time ago. I've attempted to be a servant to most anyone to maintain a home for my children or myself. It appears, regardless of what we've attempted to do to make money to pay City Financial or now City Mortgage SBM, we've been unsuccessful. We decided the other day to pull David's credit bureau report. It shows that 5 days after Judge Shermer's ruling on our initial complaint, our mortgage was reported as being sold on 6/30 of 08. We were never notified of this. We only found out because we pulled credit to try and find out how bad it is, to see if there's any way we'll be able to find a home to live in. Regardless of how these companies are somehow intertwined, law acknowledges these are separate companies. We may have had uncontrollable issues in recent years, but that doesn't excuse not telling us who now is foreclosing, or that City Financial sold our debt to another company. The foreclosure trustee unknowingly acknowledges our The foreclosure trustee unknowingly to us acknowledges this in his last foreclosure letter attached. No one explicitly let anyone know it was sold, though, by this attached notification. There was no proper assignment from City Financial to City Mortgage SPM recorded in any county records. I've always been told county records are facilitated in an attempt to notify people of such things pertaining to a property. So if such questions arise about home ownership records, that they're there for everyone to know and be aware of. To us, this should include when an account is under the handling of a potential foreclosure trustee. We understand to some degree the treatment we've received in these courts. We've always attempted to be upstanding individuals with morals and values with respect to the laws and people we encounter. We know we've been considered incapable to repay our debts. This is not totally true. I've invested many hours as a banking professional outside of this case. I've always attempted to act in a best person's interest. My children all have the same father. I've tried to give my children a stable home. From the age of 16, I've always worked. We've tried not being materialistic, judgmental, or hostile towards others. The law dictates we take care of our children or else they'll be removed from us. I've found any employer that has employed me has done nothing but deceive me once I've accepted employment. Since this happened, I've tried working from home without success. This doesn't mean I've done anything to harm another or that I have had cases brought against me for unethical business practices. I've intentionally made sure I operate within what the law is to allow, otherwise I wouldn't be able to live with myself. In good faith, I've taken City Financial clients for non-performing notes, deficiency balance notes, and REO properties via their Kansas City office. The first investor was interested in purchasing deficiency balance notes. The purchase price was $10 to $50 million per month. This not being a small transaction, I was never introduced to the end buyer. Most people in my situation would never have someone real with this purchase price capability. In transactions of this size and nature, one may never have a real idea of who the real buyer is. But the person with Kansas City office did or does know who the buyer was and that he's a capable investor. City Financial stopped this transaction from happening. They wanted to continue making money on these debts even though they were supposed to be selling them. This, of course, didn't sit well with the buyer. Therefore, the transaction failed even though it would have paid for the mortgage lien in question many times over. After this attempt, I tried to help a business associate purchasing non-performing assets of City, only to be told the buyer didn't qualify due to purchase price amounts required by City, which was a purchase price of $3 to $6 million in non-performing assets. He, however, could only purchase in the volume of up to $1 million per month, and that would have translated to about $150,000 per month to City Financial. Through a business associate I have now as well, I have an investor that could purchase REO properties with the fund to purchase them of $200 to $300 million. This investor previously has requested packages and is an approved investor with City. But City Financial won't do anything to help this investor with such an investment. They only want them to go through the bidding process. This leaves the investor to seek purchasing them through unqualified sources. This continually leaves them and us with nothing but broken promises. This isn't the only investor this happens to. There are various laws that are to be upheld in dealing with such private transactions. I tried with various companies or banks to assist them, only to be led on a goose chase in an attempt to accomplish anything. I still have these investors ready to do proper business banking. My hands have been tied in assisting them. I have some investors whose projects would have the capability to make billions for the bank that assist in the transaction fees. I can't even get banking professionals to answer as to whether or not the investor qualifies for sure or not. Or they may want the investor to open accounts in their bank when they already have operational accounts for transactions with world-known banks. I can't even get clarification as to who's right or wrong in the procedures allowed to do such transactions. The government monitors all these transactions, especially since they happen on an international basis and not usually within the U.S. territory. The transactions I've been attempting to complete would more than make our lives financially secure. We feel we shouldn't be losing our home to a foreclosure in this case, if you ask me. How can I pay when none of the bankers or attorneys has to follow basic business practices? The extenuating circumstances we covered regarding who did what in our initial complaints to these courts of justice, to us, The only one receiving justice is City Financial in their attempt to take her home along with home ec, especially since foreclosure laws dictate any lien holder has to be notified prior to a foreclosure sale. City Financial has now foreclosed, knowing the party they're identifying as the owner of our second mortgage to come forward has no clue who owns our debt. I believe I now have evidence that shows home ec could never know who owns my debt. It was found after my initial complaint to these courts. One can see we created these debts, then within a year thereafter started having financial issues. We've always attempted to do justice with City Financial to rectify this claim they have against us, even making sure they were one of the companies we use in an attempt to do proper business with. This way, they would have the control and proof of us trying to rectify our situation, until it's come clear that no one wants to recognize the illegitimate business practices introduced to us an exception to this world or loan. We know of no truth in lending law that makes one have to be responsible to pay for 2 appraisals on their home to originate a mortgage. We paid for an appraisal on the day they appraised our home and out of closing. We attempted at the closing to address this, to be told not to worry about it. The lender is paying for it, not you. This in itself was deceit as well. Truth is known. We have paid for these entities' horrible business practices. We know of no RESPA laws that allow avoidance to filing proper notification procedures of ownership entitlement. An entity notifying a homeowner of them servicing the debt is just that, a notification. They're considered a servicer, not an owner of the debt. They're required by any law we've read to show ownership to not get by with theft if requested. To us to date, these courts and entities have refused to exercise their powers and maintain any rights whatsoever in an attempt to amicably amend any misgivings that our recent financial difficulties have caused. What these banks are doing and allowed to be doing is unconscionable to me. They've had various people put their livelihoods on the line as well. We're not attempting to ask for a special privilege. We're asking the court to help with the true issues at hand. I'm unlike other people coming to these courts seeking justice for the injustices these firms cause. This business was, or is not, only my livelihood, but my life. Whether it is a big bank I'm working with or a homeowner debtor who needs solid financial information to make adequate decisions for their future. I feel if given proper assistance, these matters could be rectified in a more favorable way to all parties. If given assistance, we would not only be able to rectify this matter, we'd be able to help banks who have gone through financial turmoil in recent months, or assist people who have no one to assist them. I can't tell you how many times I get told no in getting help on my case. My question is why. These complaints aren't an easy feat with the information to do one. These complaints aren't an easy feat with the information needed to do one adequately. We don't control the banking world, but the Department of Justice, federal government, and banking business does. Respectfully submitted. And then I put the cases here, in which, I referenced throughout my complaint. And after that was written, come to find out, the company I worked for, National Asset Recovery Services, that lied about the right to sell mortgage notes, their board of directors are over 35 of the top law offices nationally, and they've been putting fraud into the courts, knowing it's fraud, since at least 1998. I can substantiate this by writing. Then come to find out, part of the reason maybe why I was treated so bad is that I've had my true identity kept from me my whole life by our government. And I found this out quite by accident. I have a grandmother who passed in 2011, and prior to death, she asked that I try to help find out what happened to her father because he went missing to her. And all she wanted to know was what happened to him, because she finally got to go to his grave before she died. But he, came to her in like 1945 or 46 and told her, said, look, you won't see me for a while. Well, the truth of the story is she never saw him again. And investigating him, the first thing I did was I called the Social Security office, and when I called the Social Security office to see if he updated his card, they said he did. And at any rate, I, wrote down the names that he updated his names with. And he put his mother down as Katie O'Hara, hasn't gone with the one. And I was like, no way possible. Katie O'Hara, Gone with the Wind? Nah, nothing to do with that. But there's too many things to point that is the case. as another family picture besides the ones that I have of my great-grandfather and my great-grandmother and everything like this, is one of America's first gold miners, William C. Whitney, who actually had a son that died at a young age, and prior to his death, he dated a girl by the name of Evangeline Crawford. His father was Captain Jack Crawford, who was tied to Buffalo Bill in the Wild West shows in the beginning of Hollywood. And Patrick Dirac was one of America's first gold miners. He did a patent for gold mining that today is even referenced by Standard Oil. It gets really scary because, him putting her down as Katie O'Hara and Gone with the Wind, like I said, I was like, no way. So far, I've actually made another affidavit. And this particular affidavit goes into the information I've obtained with that. So what I want to do is I want to start going over that for you. And help you understand that, I'm not just crazy, but, there was a reason behind what they've done to me. And I'll definitely get to the bottom of it, but here's another complaint that I attempted to file, but the clerk in the Eastern District of Missouri refused to file for the practices that I faced here in the Eastern District. I've titled this My Affidavit of Truth, referencing government corruption, enforced identity fraud, and attempted murder. And I typed this on February the 11th of 2013. In August of 2008, I made a petition to sue Senior District Court Bankruptcy Judge Barry Shermer. I pled with the courts to understand my reasoning about why Judge Shermer was incorrect in his ruling surrounding my case. I pointed to many things in my motion to vacate, things that have now come full circle for millions of Americans in their fight to keep their homes. To me, it is my duty as an American citizen to inform you of further information I've obtained. Since I filed suit, I learned that I'm not the only case Judge Barry Shermer has been found to rule inaccurately on. I found others who believe some of his rulings should be overturned. There are possibly millions lost because of Judge Shermer. I never filed this suit to bring harm to him or to me. However, report what I understand about what has happened in my attempt to clear my name. The company I complained of, NARS, or National Asset Recovery Services Incorporated, had down or has down as their board of directors two of the top foreclosure trustees in America. They are Dave Kreisman and Gerald Shapiro. I found since 1997, if not before, that they've been putting fraud into the courts, knowing it's fraud prior to putting it there. The company's mortgage electronic registration systems or lender processing services are one part of a much larger fraud upon the American people at large. One of the initial filings of my foreclosure that was proven to be fraud, the person who signed it is now a national director for loan servicing at Fannie Mae. His name is John Dunnery. Since I filed my complaint, I've had an attempt on my life made to look like an accident. In May of 2012, I experienced an odd noise with my vehicle. I thought the noise had something to do with my muffler. I had no clue it was a problem with the tire. The way I found out it was my tire was as I was driving up to a gas pump, my rear tire fell off the axle. A few minutes prior to this, I was on the highway with my 13-year-old daughter. One could speculate that we didn't attempt to maintain the vehicle. However, once previous to this incident, we had a similar thing happen with both rear tires and didn't think much of it. As a matter of fact, we purchased all new tires, studs, and locking lug nuts for the vehicle. So the chance that just one tire had the lug nuts come off to make this happen is very remote. The man that I complained of in my previous complaint, Dean Christensen, that threatened me, is part of this equation still, as I remember his comments to me that even if I found out about the money, I never obtained access to it. I had no clue what he meant, but I now know he tracked me throughout time somehow. My grandmother passed in June of 2011. Prior to her death, she asked us to investigate what happened to her father, as he came to her with fear in his eyes and told her she wouldn't see him for a while. This was around 1946. Truth is, she never saw him again. In my attempt to help her understand what happened to him, I started to investigate things in any manner possible. One of the first things I did was call the Social Security office to see if he ever updated his Social Security card. He actually did a few times. Below is the information that I was given. My grandmother wasn't even made aware of his passing. Luckily, she was able to visit what is supposed to be his grave in Fort Leavenworth, Kansas, prior to her death. She loved her father very much. She wasn't even allowed to visit her grandmother's funeral, who she loved very much as well. At any rate, when I discovered that he put his mother down as Katie O'Hara, as in Gone with the Wind, I was in total disbelief. I was like, there is no way possible this could be the case. But in researching another family member photo, I found out this definitely is the case, and this family member was Captain Patrick Henry Dirac. In tracking my great-grandfather around the country, I found nothing negative about him. After World War I found a book that says he worked for Ripley's Believe It or Not as a manager. That after borrowing money from an uncle, he liked it so much he decided to join the sideshow business and did his own traveling sideshow. He traveled the country as the Johnny Howard Sideshow, the John Howard Museum, and Johnny Howard's Hollywood Museum. We can track him up through 1970 through the billboard only. We know he knew people with Republic pictures. We also know he served in World War I. We're told Al Jolson was his bunkmate. His father served in World War I as well. In speaking with my aunt, we know he always paid his taxes in Baltimore, Maryland. I was able to find where both my great-grandfather and great-great-grandfather, E.C. Sundstrom, signed up the same day of service as Herbert Yates, who created Republic, as well on September 12th of 1918. We even have a picture of Will Rogers on set in our family pictures. We also have another with what looks like a Bush family member in it. I've also found that he knew Johnny Coons, whose father was Carlton Coons of the Coons-Sanders Nighthawks. They had the first novelty orchestra on radio. They helped fund MCA and CBS. They also had connections to Al Capone from the reading I've done. I know that MCA in the beginning was the booking agent for all the Hollywood stars. Needless to say, my grandmother traveled a lot with her father in his sideshow business. She knows that one time my grandfather witnessed President Roosevelt's plane crashing, and upon taking pictures, his camera was taken. That one time he was able to call somebody with the railroad and get permission to use an automobile on the railroad to make it to his destination quicker. That one time, at a venue to see Louis Armstrong, someone bombed their vehicle. The articles in the billboard never speak negative of him. Tracking him has been difficult. Johnny mainly used St. Louis as his home base. He traveled nationally with his sideshow business and was known to people unknown to us. St. Louis was the main hub for the Showman's Club he belonged to, which was the International Showmen's Association. He was a Shriner. The club regularly held benefits for the Children's Hospital here in St. Louis. I've located a person who worked for him about 11 years before he passed. He said that he was somewhat of a loner and kept to himself, that he encouraged people to be all they could be, that he tried to recognize people for their own individual strengths, that he was well liked by the people who worked for him. He was as well known as Sally Rand, the Four Tops, Leon Clarkson, and Hetty Jo Starr. My great-great-grandmother, Iva Mae Schuster, is even buried at a plot owned by the Showmen's Association in Memorial Park Cemetery. When my grandmother died, we buried her there with Iva Mae. Iva Mae was the daughter of Henry Louis Schuster. I know she had to appear at his trial over what was supposed to be the sale of a horse, but ended up being about his land. I also know that at one point in time he was shot by Jesse James, but lived through this incident, as we have a family member who has informed us as such. I have reason to believe that Henry was related to the Schuster banking family of St. Joseph, Missouri. Ancestral records for the family members are sequential to those of Adam Schuster. He was a prominent banker in St. Joseph, Missouri. He had the largest wholesale clothing warehouse in the Midwest. I know he was in the clothing business with Victor Sidney Rothschild. He helped build railroads from his own funds. He also had various businesses. I'm aware that he took a hard hit on his assets. I'm aware that he was involved in the start of many banks in Missouri. I know that he was business partners with John Calhoun, who I have reason to believe is the same that helped Abe become a surveyor back in the day. I also know that Mr. Calhoun died of a strychnine overdose on a visit to St. Joseph when he died. Mr. Calhoun also had the first newspaper in Chicago, Illinois. I also know another business partner was Lewis Hacks, a furniture manufacturer back in the day, who died underneath mysterious circumstances while being in robust health the day before. I know wives of his associates were at the opening of the Pony Express. Another close business associate of Colonel Adam Schuster was James Nelson Burns. History records say this about him. James Nelson Burns, August 22nd of 1827 to January 23rd of 1889, was a U.S. representative from Missouri. He was born in Indiana. And he went to common schools. He graduated from Harvard Law. He was admitted to the bar and commenced practice in Missouri. He was an attorney for the District of Missouri in 1856. He served as a judge of the Court of Common Pleas from 1868 to 1872. He engaged in banking and the construction of railroads. He served as president of the Missouri Valley Railroad Company, principal owner, and president of the St. Joseph Waterworks. He was an elected Democrat to the 48th, 49th, and 50th Congress and served from March 4th, 1883 until his death. Despite the small overlap, one of Burns' few motions was defeated by President veto of Ulysses Grant. He had been re-elected to the 51st Congress but died in Washington, D.C. on January 23rd of 1889, before the commencement of the congressional term. Even if it can't be proven that I am related to this family, I know for sure that Mr. Dirac was a connection to the Whitney family. I doubt very seriously if he wasn't related he would be in my family pictures. I have reason to believe his wife Julie was a sister to my great-grandmother Catherine. In investigating members of Gone with the Wind, I found various mysterious deaths. They are Margaret Mitchell, who was hit by a hit-and-run driver, George Reeves, the first Superman who died from apparently a gunshot wound that was ruled a suicide, Sidney Cohoward, who died prior to the movie being released in a tractor accident on his farm, and Leslie Howard was shot down. Then we have my grandfather who went missing and probably a couple other people. However, John, or Johnny's father, E.C., or Edward Charles, and whether he be a Sundstrom or a Howard, lived in New Mexico, and he was a railroad conductor for the AT&SF Railroad. He was rear-ended by a hit-and-run driver prior to his death in 1933. He died within a couple of months from complications this accident caused. We don't think this was ever investigated. Besides being a conductor for the AT&SF Railway, he was on a special committee for them, as I found a picture of them in Dodge City, Kansas. I have a picture of him in family pictures. I have reason to believe members of his family helped build the waterways in New York City. The main link to showing I'm the great-great-granddaughter to the real Katie O'Hara, as in Gone with the Wind, comes from Patrick Henry Dirac. He was one of America's first gold miners. Texas records have his first name as Dirac, D-U-R-A-C-K-E, instead of Dirac, ending in K. However, other records show him as Dirac. I now know William C. Whitney was heavily invested in his gold investments back in the day. It was William C. Whitney's grandson, John Hay Whitney, that funded Gone with the Wind. Jack's mother was Helen Hay, the daughter of John Hay, Abraham Lincoln's right-hand man. I know Patrick's son was killed in a diving accident in El Paso, Texas, that he dated a girl named Evangeline Crawford, whose grandfather happened to be Captain Jack Crawford, one of America's earliest poets. Captain Jack Crawford was also friends with Buffalo Bill, who started the Wild West shows. Captain Patrick Henry was an engineer and miner associated with President Cleveland and William C. Whitney, along with the firm Corralitos or the Candelaria Mining Company. He had various investments in gold, coal, and others unknown to me. I found advertisements by him describing how heavily invested Mr. Whitney was in gold investments. El Paso newspapers also speak about him being present to talk about his gold mining or coal mining opportunities. I know, besides living in El Paso, that he lived in St. Paul, Minnesota. The newspapers advertising the investment opportunities were in Baltimore, Maryland. Patrick Henry Dirac was also involved in making Barstow, Texas come to fruition back in the day. Some Texas records spell his records... Oops, sorry, I lost my place here. Bear with me. Okay. Some records spell his last name as Dirac instead of Dirac in the records here. He was also considered the sheriff on the Pecos. Mr. Dirac's gold mining patent is even referenced by Standard Oil. He also got help from the Santa Fe traders at one point in time through President Cleveland. Patrick also stopped some men being hung once through a diplomat in Mexico. Mr. Dirac is mentioned in university books from Michigan. He had railroad patents and gold mining patents. My grandmother knows that up until probably 1948, her family still had mines in the family. What type for sure I'm unaware. I know Patrick Dirac resided in St. Paul, Minnesota as well, and possibly built railroad bridges there besides being a gold miner. I know in reading various things I came across the mention that my great-great-grandmother possibly helped the KGC or KKK avoid prosecution by giving them an alibi. Nothing in Gone with the Wind mentions this, but the book possibly does. I and my family members are unaware of such connections, but it's obvious to me that people are aware of what really happened to my family members or whatever they were involved with. Since my complaint about Judge Shermer, I found another case that a firm almost lost $33 million over his actions. In this case, he attempted to dismiss their claims for lack of jurisdiction. It's my understanding that if a judge is found to have ruled without having jurisdiction, that he is not immune from lawsuits. Therefore, I don't understand how Judge Mitty could have given him immunity for his actions. It was found he didn't have jurisdiction to dismiss their claims. Information regarding this is below. And there's another attorney that speaks ill of Judge Shermer because he was visiting Florida, and he spoke about how, he'd be one of the ones proud to try to get one of his orders overturned because he was going to have a lot of them to go through because that's how poor his business practices are. At any rate, I came to court with honest information about what our country was about to go through with the impending foreclosure crisis. I just had no clue who I really worked for or how associated they are with everyone. I've also been left to wonder who I really am. It's a case of a government-enforced identity fraud to me. I still believe I shouldn't be forced into a Chapter 7 bankruptcy over the way I have to pay my bills, not to mention the fact that I come from a family whose heritage has been kept from me or other family members. The fact that they were some of the most prominent members of society at one point in time, to be left penniless without a clue as to why and what happened is very discouraging. To be left in the dark as to why anyone would want to hide such things from you about your family, to have someone haunt you about events that happened that you were unaware of is even more disheartening than any of the other things I have spoken of or uncovered. To constantly live in fear that someone knows things unknown to you that could leave you dead with no one to protect you is just wrong. I believe having a disqualification of one federal judge and two separate recusals say a lot about the truth I represent to the equation. Recusals exist to show sometimes the court should show some impartiality. Given the opportunity, I have a way to rectify so many things that have happened in recent years in our country, banking-wise. I have to wonder at what point anything is based on the truth with everything I've uncovered. I'm a good person, and my family members are good, upstanding citizens as well. In the near future, I will face yet again a Missouri judge regarding the divorce I'm about to go through. I may be left with no way to pay my attorney to represent me. Not that I haven't applied for jobs, but my attempt to do right has hindered me to no end. I may even lose custody of my children over not having a way to support them. Since the filing of my motion to vacate, we have had our business plan approved with a senior vice president of finance at City. He, however, claims that he doesn't know who to take it to within City, that it would have to be done through the New York office, possibly in the capital markets. Whatever my family did doesn't include me. To me, our country deserves an opportunity to recover from such instances instead of facing such tyranny for the next 10 to 20 years. Our other business adventures could put America back on top as being one of the most powerful countries in the world. They may even help us keep our world status as the world's currency provider. Our products outside of fixing the foreclosure crisis would eliminate the need for charging stations for electrical cars. It would also eliminate the need for gasoline for rear-wheel drive vehicles. They would also eliminate the need for everyone to have an electric bill. These are things that would allow the American consumer to save money, to not overextend themselves, to be given a fair opportunity, to be given a chance, and the one life we all have to live. Some corporations may not like these ideas as they may lose some money, but they could also be advantageous opportunities for everyone involved, not to mention the jobs that would be created on American soil. They would help American citizens get back to work. Citizens would be restored and being given the opportunity to be upstanding individuals they are. The government would have to worry less about welfare for the people as they would be paying their way again. It's in God's grace I beg of you to consider the things mentioned in this affidavit. I know of no one who would want to have to experience the things I have for so long. Sincerely, Catherine Udis. And yet, you know what? No one will help. So here we go, folks. Now you know how I feel. And God bless you in finding your foreclosure or figuring out what you might figure out as well about your family or, the life that we all have to endure. It's not an easy one.